One of the biggest myths around inheritance disputes is this idea that only spouses or blood relatives can challenge a will. In reality, the law in England and Wales is much broader than most people realize, and every year we speak to people who simply didn't know they had rights. So let's break it down. Who can actually bring an inheritance claim? Inheritance claims usually fall under the Inheritance Provision for Family and Dependants Act, 1975. The key question the court asks is whether the deceased made reasonable financial provision for the people they were responsible for or closely connected to. Spouses and civil partners are right at the top of the list. If you were married or in a civil partnership, you can bring a claim even if the will leaves you very little or nothing at all. The court can look at what would be fair based on your standard of living, your age, health, and the length of the relationship. Then there are former spouses or civil partners. This often surprises people. If you were divorced but never financially separated through a clean break order, you may still have a right to claim. We've seen cases where an ex-spouse assumed it was too late, only to find they were still legally entitled to bring a claim. Children are another key group. That includes adult children, not just minors. A common scenario is a grown-up child who is financially dependent on a parent, perhaps due to illness, disability, or long-term financial difficulty. If that support disappears overnight, the court can step in. Partners who aren't married often assume they have no rights, but that isn't always true. If you lived with your partner for at least 2 years before their death, you may be eligible to bring a claim. We regularly act for people who shared a home, shared bills, and built a life together, only to discover the estate has been left elsewhere. So, here's a real-world example. Sarah lived with her partner for 8 years. His will was old and left everything to his siblings. After his death, Sarah struggled to pay the mortgage and household costs. She wasn't looking for a windfall, she just needed stability. She was able to bring a successful inheritance claim because of her long-term cohabitation and financial dependence. Finally, there are dependents. This category is actually wider than many people expect. A dependent is someone who was being financially supported by the deceased immediately before their death. That could be, say, a stepchild, an elderly relative, or even a friend in some circumstances. The court will always look at the facts. Financial need, the size of the estate, the relationship with the deceased, and what provision has already been made all play a role. Timing is crucial. In most cases, you only have 6 months from the date probate is granted to bring a claim. If you miss that deadline, things become far more complicated. If you're unsure whether you qualify, that uncertainty alone is a reason to seek advice. Many people, rule themselves out far too early. At Blackstone Solicitors, we help clients understand their position clearly and realistically, so they can make informed decisions at what is often a very emotional time. If this topic resonates with you, it may be worth getting advice sooner rather than later.